interesting and really exciting to have people together to discuss these issues. Usually it's just in passing that we get to discuss them in hallways and in small meetings, but it's nice to have it in this form. The next series of panelists, also from the trenches and beyond, are Raj Anand, Kim Murray, and Andrew Pinto. We'll start with Raj Anand. Mr. Anand practices in the areas of civil litigation, professional negligence and discipline, human rights, constitutional and administrative law, and labor relations. He's the former Chief Commissioner of the Ontario Human Rights Commission and presently acts for complainants and respondents before the Ontario and Canadian Human Rights Commissions. He's acted as a board of inquiry under the Ontario Human Rights Code and the Police Services Act, and has acted as counsel to a number of administrative tribunals, including 2 human rights commissions, the Ontario Labour Relations Board, the Workers' Compensation Appeals Tribunal, the Pay Equity Hearings Tribunal, and the Office of Adjudication of the Ministry of Labour. A lot. Mr. Anand has spoken and written on diverse subjects, including trial, appellate, and administrative advocacy, and human rights, and currently serves on the editorial board of the National Journal of Constitutional Law. He graduated with the Dean's Key in 1987 from the University of Toronto, Faculty of Law. He was appointed by the Ontario government on the law concerning trespass to publicly used property as it affects youth and minorities. In 1997, he was the first recipient of the Advocate Society Award of Justice. Mr. Anand chairs the Minority Advocacy and Rights Council and acts for a variety of non-governmental organizations in public interest litigation. And on a personal note, he was also my articling principal, and I sort of learned a lot in my first steps of race litigation from Raj. So thank you very much, Raj.
Thanks very much, Michelle. I intend, in the time that's available, in keeping with Peter's 20 hours remark, to try to touch upon a number of sort of a smorgasbord, if you like, of topics relating to race tribunals in the courts, hopefully with some coherence, because I do intend to jump around a little bit. I want to make some preliminary remarks, though, before getting to some of the sort of nuts and bolts issues that we in the trenches are supposed to know something about, and just say something about the what I regard as the differential treatment of race cases in comparison with other grounds. And I say that from the perspective of someone who's been involved in some human rights and constitutional cases involving a variety of different prohibited grounds under Section 15 of the Charter or under the different human rights codes. And it's, Michelle actually began today by touching upon the refusal of courts and tribunals to, and indeed the Canadian public, to recognize racism. And that has been, I think, a persistent theme through the presentations that you've heard thus far, and it's clearly a valid theme. I would go, and it has led to some proposals such as reverse onus and other means of dealing with this, with the reality that racism today is not likely to be displayed. It's recognized to be antisocial, but it's not, its prevalence and its sometimes subterranean nature has not been recognized. I would go further and to say that because of that extreme abhorrence in principle, which has, again, historical roots in the 20th century, in the history of the 20th century, I suppose, because of that, adjudicators are reluctant to recognize cases involving race in circumstances in which I would suggest they would recognize cases involving other forms of discrimination. We've heard something about inquests excluding race as a consideration. I would go further and say that some of those same inquests have routinely considered mental illness and have allowed standing to groups representing persons with mental disabilities in situations in which they've denied standing to racial minority groups. immigration cases, clearly in an area in which race is a prevalent and a factor lying behind the scenes, if you like, very few talk about Section 15 and race issues. The gains in the Supreme Court have been largely through other grounds, even though the gains under, for example, in the ebbs and flows of equality jurisprudence under Section 15, which I'm sure most of you are quite familiar with, have largely been through cases involving gender, religion, disability, and in the case of overt discrimination, sexual orientation. Michelle mentioned that I'm involved with an organization called MARC, the Minority Advocacy and Rights Council. We established ourselves about 10 years ago with aspirations to become an ethnic leaf, because LEAF has been remarkably successful in my view. They've had setbacks, and they've done an enormous amount of good work, and their systems their systems and their people are much to be admired. We've intervened in a few cases, in three or four cases at the Supreme Court level now, but those have been interventions in cases not directly involving race. Religion cases under Section 15 of the Charter and the Human Rights Codes, and I think of Simpson-Sears and Central Alberta Dairy Pool, Bergevin, the religious holidays case, Renault, the union case, interestingly, have all been religious cases, have all been discrimination on the grounds of religion, which, at least in the experience of human rights commissions, has been a relatively small, a relatively infrequent ground of complaint, certainly in comparison with gender, race, disability, and so on. And more recently, there have been some substantial gains, I would suggest, in the area of disability in cases like Eldridge and Mior and the BC firefighters case, and the recent motor vehicle case whose name escapes me now, the license case. I've suggested this at other forums, and Carol, I know, was at another forum in which I suggested that indeed there is this differential treatment, which led to some, I suppose, spirited debate amongst other groups who felt equally slighted. But that aside, I guess I maintain this. Now, what does that do apart from moaning about the treatment of racial minority groups? How does that assist us? I would suggest that it may color or tailor our approaches to some of these cases in terms of how they are to be advanced. If a particular proposition, I'll try to be a bit more concrete about this in a moment, but if a particular proposition is intended to be advanced, and if you're in the early stages of the planning of a constitutional case, for example, a Section 15 case, I would be firmly of the belief that everything else being equal, and there are lots of factors which I'll touch upon in terms of applicants and approaches and so on, but if everything else being equal, one may wish to take a case under a different ground, quite frankly, and use the racial minority angle and the racism issue as an intervention issue rather than a direct form of application. In the time that's available, I can't really get into all the reasons, I suppose, which lead me to this belief. But let me just touch upon some of the obstacles which are particularly important in race cases. But I suppose one of the lessons to be drawn, if there is one, is that the same kinds of factors apply to other grounds. when I talk about intervening, I don't mean that we simply give up and not take any direct cases. What I'm pointing towards is something which other speakers have touched upon as well, and that is the need to form coalitions and alliances and to move forward together. On a lot of these cases, as you well know, in the Supreme Court of Canada, there are allied interventions from a variety of disadvantaged groups and their representatives. The Breen case, for example, which Andrew and I worked on behalf of a gay and lesbian group, was one in which there were, I think, 17 different interveners, and most of them represented groups other than gay and lesbian organizations, religious, race-based, gender, and so on. Particularly in the race area, there are a variety of obstacles, costs, which, again, these aren't unique to race litigation, but they clearly have been a substantial obstacle for racial minority groups. Costs, the form of the application, it's one of the early sort of preliminary issues that one needs to address is to advance a test case. Is this going to be an action? Is this going to be an application? Is this going to be an application for judicial review? Is this going to be a class proceeding? There are problems of standing, clearly. Despite the sort of wide language of the Breen case and the narrow language, I suppose, of the Canadian Council of Churches case, the lower courts, in my view, have been quite restrictive in granting standing. It's almost a truism that it's difficult to be denied standing, in my experience at the Supreme Court of Canada, but it's very difficult to be granted standing for the same intervener or the same applicant where it isn't a money issue at the lower court levels. The lower courts deal largely with commercial cases. I'm speaking now of the civil courts, obviously. They deal largely with money cases, and they generally understand if somebody's been denied money through an alleged constitutional violation. I'll give you an example. There's a case which we have ongoing in which the welfare deduction for sponsored immigrants is being challenged. If you're a sponsored immigrant, you get less welfare in Ontario than if you are not sponsored. And the rationale is that you have a sponsor who should be paying, regardless of the fact that in the case of our applicants and in the case of anybody who's complaining about this, their sponsors are nowhere to be found. There was either an abusive relationship, or they've disappeared, or they're dead, or for a lot of other possible reasons, they're not available to provide assistance. That's a money issue. It involves at least $100 per month for somebody who isn't living with the sponsor, and it involves the whole shelter allowance for the person who is living with his or her sponsor. And that's something in which there can be sort of traditional damage principles applied, and indeed we brought it as a class proceeding, but it's going forward as, if you like, as a test case with the class aspect of it, including certification and so on, being deferred, so that first the constitutional violation will be assessed, and the damages issues, which are more nuts and bolts and less of a test case variety, can be dealt with after that. In these constitutional cases, I want to touch upon just two issues, practice issues, if you like, in formulating the cases: statistical evidence and expert evidence. I would suggest that certainly in the year 2000, with the public opprobrium that's attached to overt racial slurs or racially discriminatory acts, and with all of the experience that you've already heard about involving racism being more of a systemic nature and lying behind the scenes, it seems to me that statistical evidence of exclusion from benefits, from employment, from assistance of some kind is very important and is likely to form the foundation of a case of constitutional violation of inequality. It's unlikely that you're going to find a statute or a regulation or a rule formulated by a government which overtly distinguishes on the basis of race, color, national, ethnic origin. Although the sponsored immigrant challenge that I mentioned comes pretty close, in my view. When one takes only a moment to look at the makeup of immigrants to Canada, it's pretty clear that what's being targeted is a group that is vastly disproportionately of racial minorities. So disproportionate impact is a ground on which a number of these cases will have to go forward. The Beth Symes case from 1993, in Justice Iacobucci's decision, although it's obiter because he found against her on the ground that she alleged, which was gender discrimination, Justice Iacobucci, in some fairly strong remarks, pointed to what the case would have been like had the group involved been single mothers, and the disproportionate impact in terms of cost of raising children, which was the issue there. It was an income tax case. The Sparks case in Nova Scotia is one of the few that I'm aware of in which the disproportionately black racial makeup of the public housing tenant group in that case, which was disadvantaged in comparison with private housing tenants in terms of notice to quit, if you like. That was one of the few cases in which that makeup was considered in determining that the public housing tenant group was a disadvantaged group. It was made up not only of disproportionately black people, but single mothers and persons on welfare. A similar kind of statistical analysis has been accepted thus far in a case called Faulkner against Ontario, which is a constitutional challenge to the spouse in the house rule in this province, which has already been heard at two levels, divisional court and back to the Social Assistance Review Board. It's now back at divisional court. I won't go into the ins and outs of that case, but it is under reserve, has been since late September, on precisely this issue of whether, among others, of whether there is disproportionate impact of women on women and single mothers, both of whom, women being enumerated and single mothers being analogous or a subset of an enumerated group. One would have thought that it's a fairly obvious deduction where 95% of single mothers are female, and it's single mothers who begin to co-reside with a member of the opposite sex that lose benefits. And the statistics show that 89% of those affected by the Harris government's spouse in the house rule as of 1995 are women. A similar argument failed in the case challenging the megacity legislation, where the statistical argument is one which I would suggest is relatively easy for courts to get out of, because they can always perhaps point out the frailties of the argument. The megacity case is a good example in which I was unsuccessful. Essentially, the argument was that that Toronto, the former municipality which became the city of Toronto, was composed of was a disadvantaged group. That isn't the technical way of putting it, but that's what it amounted to, because the electoral representation for the municipality of Metropolitan Toronto was vastly decreased from an already decreased position when you compare it, in essence, to the 905 belt around Toronto. And I don't have the exact figures at hand, but the ratio was something like 4 to 1. If you lived north of Steeles, you had 4 times as much representation than if you lived 1 block south of Steeles. 4 times as many people were represented by the same councillor in the city of Toronto, and it had already been disproportionate. So the argument was that in a municipality which was already the destination of a disproportionate number of immigrants, of people who were disadvantaged in other ways, the effect of this legislation was to further impair their political rights. The court sort of ignored that statistical evidence, quite frankly, and I suggested as an example of how easy it is to ignore statistical evidence, and simply said, well, that's evidence of sort of raw figures of representation, that your councillor will be 1/4 as much available, everything else being equal, but everything else isn't equal. Your councillor may be better, may be more forthcoming, may spend more time at meetings and out in the community than somebody in the town of Vaughan. And so it was sort of easy to just sort of shift and to say, as the Court of Appeal did, there is no evidence of the impairing of electoral or political rights, because you would have to call evidence of 2.2 million people suffered individually. Some people aren't interested in politics, and so how can they be said to have suffered from a political standpoint? Anyway, I don't attempt to defend it so much as to simply indicate how slippery it is and I confess not to have sort of formulated a jurisprudential explanation for this, but my sense is that in these cases where one has to show some disadvantage, some negative impact, the disproportion argument, particularly with judges who are not math professors, like Peter Rosenthal, or who didn't aspire to be math professors, such as myself, who didn't get beyond a first degree in math, don't understand these very well. Which leads me to the expert evidence issue. Judges need help. In this area. And there are 2 sort of sub-areas that I would suggest, and I don't suggest judges are unusual in that regard at all. The first is expert evidence on analogous grounds, and this is something which has been a feature of many of the cases that I've described. Clearly, in order to establish sexual orientation as an analogous ground, expert evidence was required. Poverty as an analogous ground is a hotbed of contention between government and NGO groups taking forward constitutional cases. Needless to say, from the standpoint of governments, the implications of poverty being established as an analogous ground, thereby subjecting a wide array of governmental programming to constitutional scrutiny is anathema. And so there are regular experts who are trotted out and regular reports which have been prepared for this purpose. Receipt of public assistance. Again, there are lots of cases in which this has been adjudicated with mixed results. And again, it's one of the issues in the Falconer spouse in the house case that I mentioned a moment ago. The second area of expert evidence is on impact. And it may be that in the megacity case that I described earlier, what was lacking on our part was expert evidence of the electoral proportionate impact translating readily into a true political impact. I guess, formed the judgment that it wasn't required in that case because if you look at the electoral boundary cases, which this wasn't, because it wasn't in the context of directly in the context of the section of the Charter dealing with the right to vote. But in those cases, the Supreme Court has said that a rough proportion is required between different electoral districts. They shouldn't be a 4-to-1 ratio. And indeed, in one of the cases that went to the Supreme Court, a ratio of, I think it was 1.5 to 1, was held to be too much, and therefore the right to vote of those who were disadvantaged had been denied. But it seems to me that that's an area in which political science evidence may well have been useful. I'll stop there. Thanks.
Thank you, Raj. It's very helpful. And I think one of the themes that's coming out that we were hoping to put forward here today is that there are race issues that arise within the context of any given case that might come in your door that's not a strict race case. But there are also times when we want to push race test cases, when we do want to sort of maybe go against the grain and know that that's not the most popular ground to move on, but it's something that we need to do in terms of social justice and progress. So hopefully you'll sort of see two of those themes coming out. Our next speaker is Kimberly Murray. I know her as Kim. She's a Mohawk and member of the I should have asked how to pronounce this, I'm sorry. Kanesatake Mohawk Nation, thank you. She's been employed with Aboriginal Legal Services of Toronto, which is one of the legal clinics here, since her call to the Ontario Bar in 1995. A staff lawyer, and she's now the director. And she's an LLM candidate at Osgoode Hall Law School in Constitutional Law. Was co-counsel with Professor Kent Roach before the Supreme Court of Canada in the Queen and Corbière, Gladue, and also Gladue and Wells and the Queen. And if you don't mind my saying, she's also has a new little girl as well. So she's been very, very busy. Kim.
Still getting used to that. My resume seems so short after all the other people that have spoken already today. My experience, as Michelle said, is strictly with working at Aboriginal Legal Services of Toronto. And so when I talk about in the trenches, I'm talking about just the short time that I've been in the trenches, but I've learned so much from the people that I've worked with over the years. When I was asked to present today, my first thought was, oh, do I have time? But then I thought about it some more. We get so many calls at the clinic from our community members and our clients complaining about their lawyers. So I thought, what a great opportunity to come and talk to some lawyers about representing Aboriginal people. Especially now, most of the complaints, I might add, are with regards to the residential school litigation that's occurring across Canada. We're having, it sort of is a cash cow for many lawyers, and there's lots of complaints from the community of lawyers coming in, sweeping into the communities, whether it be a northern community or here in the city, throwing questionnaires at the client saying, fill these in, and they're raising up things that people have kept buried for a long time about the treatment they received in residential school. And lawyers are just coming in and asking them to bring that all up again. There's no support put in place for them following this, disclosure of the sexual assaults that occurred to them. And so, and then the lawyers are leaving and not providing any assistance for the clients, and then they're not there to respond to calls. And So I thought it's a great time to come and talk to some lawyers. I'm not suggesting that anyone in this room is one of those lawyers, but I thought, seeing that it's being videotaped, maybe one of those will see it. As Michelle said, Aboriginal Legal Services is a legal aid clinic serving the Toronto Aboriginal community here in Toronto, which is estimated to be about 80,000 people. We practice in various areas of law, including the regular clinic law that you see other clinics practicing in, such as landlord-tenant, employment standards law, workers' rights. So we do lots of SARBs, and we're involved in the Faulkner case. But we also do interventions. This is a new area of law that we've gotten into in the last couple of years, interventions and test cases. It's in all the areas that we practice in, we always have the Aboriginalness issue to raise. And it's interesting because we don't normally have the problem of trying to determine whether there's a race issue in our case, because normally when it's an Aboriginal client, it's normally always an issue. Whether it's at the administrative law, criminal, or civil law area, it's usually guaranteed. So we don't have to sort of search about how we're going to make the argument because it's staring us in the face. So racism, I think everybody knows that racism against Aboriginal people is chronic and is deeply entrenched into the fabric of our society and in history. As Carol mentioned earlier, it's important that we look at the history when we're raising the race issues. The Supreme Court of Canada recently told us what we've already known, that there's widespread racism against Aboriginal people, and it's translated into systemic discrimination in our justice system. The challenge for lawyers and for us at Aboriginal Legal Services is how to best present the Aboriginal realities and perspectives to the court and to the tribunals, so that the courts can identify what the racial and systemic issues are. It's important that in doing that you have knowledge and understanding of the history of Aboriginal peoples in Canada and the historical disadvantage that they've faced. And Carol touched upon that earlier about how you need to educate yourself. You can't just take the case up and say, okay, I'm bringing a Section 15 case without doing the research and having an understanding and speaking to the community. So I'm going to give you some of that information right now. Aboriginal people following European contact were displaced physically and denied access to their traditional territories. They were also displaced socially, culturally, and politically, and subjected to intensive missionary activity whose aim was to, and I say this in quotes, civilize the savages. If you go down to the archives in Ottawa and look at the records from the Department of Indian and Northern Affairs, they actually refer to our community members, and not that long ago, we're talking within the last 20, 30 years, that Indians are uncivilized. This was the whole background to the implementation of legislation such as the Gradual Civilization Act, which is, and its successor, the Indian Act. Those legislations regulated every aspect of Aboriginal people's lives. They implemented very oppressive measures that infringed upon Aboriginal people's daily activities that non-Aboriginal people had the freedom to do. Aboriginal ceremonies such as the potlatch were considered to be a crime. So if you were practicing your ceremony, you could be convicted and put in jail for 6 months. People weren't allowed to leave their reserves. There was a pass system that was implemented. We saw this mostly in the prairie provinces, where if you wanted to leave your community, you were shuffled off onto the reserve, and if you wanted to leave the boundaries of the reserve, you had to get a pass from the Indian agent to get off of that reserve. So the mobility of the community was really infringed. Aboriginal people weren't allowed to vote in the federal election until the 1960s. 1960s, that's not that long ago. Residential schools, we all know about residential schools. The last residential school didn't close until the 1980s. So we're talking about recent history when I say history. We're not talking about way back in the 1800s. This is stuff that has happened in the last, well, I guess it was last millennium, but in the last couple of decades. The government's assimilation and civilization policies have embedded generic prejudices against Aboriginal people and have created stereotypical attitudes. The Supreme Court of Canada in Williams, a few people mentioned that case earlier, that's the jury case, cited a quote from Locking Up Natives in Canada when they were identifying some of the stereotypes. I'm just going to read the quote to you. Put at its baldest, there is an equation of being drunk, Indian, and in prison. Like many stereotypes, this one has a dark underside. It reflects a view of Native people as uncivilized and without coherent social or moral order. This stereotype prevents us from seeing Native people as equals. So we have to ask ourselves, how do we attack the stereotype, and how do we cleanse the justice system of racism? Williams allows criminal courts to take judicial notice of racism against Aboriginal people. And it allows an Aboriginal accused to challenge a potential juror on the basis of racial bias. And that's what Donald talked about, how he would want to question the jury members individually. In Williams, it's important when you read the decision, and to keep this in mind, in Williams, the accused lawyer, when he was making his request to question jurors for racial bias, he filed an affidavit on behalf of Mr. Williams. And in that affidavit, Mr. Williams said that he hoped that the 12 people that tried him were not Indian haters. The questions that Mr. Williams wanted to ask the jurors to determine if they were Indian haters were as follows. 2 questions. Would your ability to judge the evidence in the case without bias, prejudice, or partiality be affected by the fact that the person charged is an Indian? And the second question was, would your ability to judge the evidence in the case without bias, prejudice, partiality be affected by the fact that the person charged is an Indian and the complainant is white? Well, the Supreme Court said that since racism is widespread in Canada against Aboriginal people, that Mr. Williams couldn't have a fair trial unless he was allowed to ask those questions. So it's a great case for Aboriginal accused. What we believe at Aboriginal Legal Services of Toronto, that if we know that racism is widespread in the justice system, why shouldn't Aboriginal people be permitted to adjust the potential for bias at all levels, at all courts and all tribunals? For example, something that we're trying to push the envelope, as Donald mentioned earlier, is that we want to have the right for the Crown to question potential jurors on the basis of bias and prejudice when the victim is an Aboriginal person. The stereotypical views of Aboriginal people results in Aboriginal people being less worthy of protection. It's interesting because Aboriginal people are more likely to be the victim of a crime than a non-Aboriginal person, yet they're less likely to report that crime. And that's because of the institutional bias against Aboriginal people and how they're just simply not believed. So we would like to have it standard that the Crown, when the victim's an Aboriginal person, asks those same questions of the jurors. Are you going to be able to determine this case without bias, given the fact that the person who is the victim is an Aboriginal person and the person who is charged with the offense is white or non-Aboriginal? So that's the whole notion of pushing the envelope. And you can even try and push that further, which we're going to try and do, and raise other stereotypes, direct stereotypes related to Aboriginal people. Are you going to be able to determine this case on the basis that, without bias, on the basis that the victim is Aboriginal and that he is an alcoholic, or that the victim is Aboriginal and he has a criminal record? Because those are the stereotypes that people have. So we should be able to challenge that. As lawyers, we have to be bold and address the issue of racism head on. Aboriginal Legal Services of Toronto, as Michelle mentioned earlier, we were interveners in the Gladue case, which is a recent, for the people that aren't criminal lawyers, is a recent Supreme Court of Canada case that dealt with the interpretation of 718(2)E of the Criminal Code. The section directs a sentencing judge to consider all available sanctions other than imprisonment that are reasonable in the circumstances for all offenders, with particular attention to the circumstances of Aboriginal offenders. The Globe and Mail called it a get-out-of-free ticket. Or no, it wasn't the Globe, I think it was that new paper. That doesn't let you write into the editor, so I won't mention them. It was when we were at the court, in our factum, in our oral argument, what we did was we presented what are the circumstances of Aboriginal offenders, and also what we wanted to do was challenge the myths that are out there. The same sort of notion that was done with the sexual offense cases where the court recognized that there's certain myths. We wanted the court to recognize that there's myths about Aboriginal people. And it was very clear to us when we were at the court that some members of the court hadn't read our factum. I won't say which. Because within 5 minutes of oral argument starting, several of our myths and stereotypes that we had in our factum came out. They were conveyed in the questions from the court, from the bench. So 2 of those myths were what we called, we had catchy names for them, the connection to the community myth and the urban Aboriginal myth. Essentially, the myth is that only Aboriginal persons who are closely connected to a reserved community are deserving of recognition as an Aboriginal person, and that urban Aboriginal people are not Indian enough to be considered Aboriginal. Well, you can get the tape from CPAC because it's quite entertaining. One of the members of the Supreme Court was clearly of the view that you're not Aboriginal unless you reside in a northern community. You speak only an Aboriginal language, and you get up every morning and you go hunting and fishing for your family. Questions that were asked of counsel were, why should a person who grew up in the city, who's never been on a reserve or lived on a reserve, who was adopted and raised by a white family, and who's now the vice president of Chrysler. That was one of the things that he said, the vice president of Chrysler. Why should we consider that person to be Aboriginal? And what was appalling was, one, was the inference that an Aboriginal person, first of all, couldn't possibly be the vice president of Chrysler, you know, the way the question was worded. But it just really showed us that, you know, here we have the top, you know, legal minds of our country, supposedly, that are carrying these stereotypes and myths with them. It's not just the judges. Sorry, I have to go back to my script here. I got off track. It's not just the judges and the lawyers that have to look at themselves and question what myths and stereotypes they have about Aboriginal people. It's amazing how many times, well, it's with the lawyers. We get so many calls from criminal lawyers. We run a diversion program at our office where we divert Aboriginal offenders from the court system. And they come to our office and have a community council hearing. And the criteria to be eligible for diversion is that, one, you self-identify as Aboriginal, and two, depending on the offense, we need the Crown to consent. Well, it's interesting because we get so many lawyers, criminal lawyers, who call us and say, oh, I didn't think that person could be diverted. You know, they grew up in the city, they didn't live on a reserve, they don't have Indian status. You know, they just didn't think that that was a possibility that this person is Aboriginal. And so it never entered their mind to consider us. At Gladue, the court states that the legal counsel, it's up to the legal counsel, or it's an obligation on legal counsel to adduce evidence to present the circumstance of Aboriginal offenders to the sentencing judge. It's amazing, this is some of the work we're doing now, is making sure that lawyers do that. Many criminal lawyers still aren't presenting the circumstance of Aboriginal offenders to the courts when they're at sentencing for their client. And I mean, it's our view that that is negligence, that when a lawyer doesn't present the best case for their client and use the tools that are available to them and follow the case law, that that's negligence, and that, you know, our clients should be filing complaints against their lawyers. Challenging the system's notion of who is Aboriginal is only one of the areas of aspects of the work that needs to be done. Another aspect is with respect to challenging the stereotyping around whose face is the face of a criminal, and Donald touched on this earlier. If the notion of criminality is linked to one's appearance, then not only will that person be targeted by the criminal institutions, they will also be denied the same level of treatment by non-criminal institutions. With respect to the criminal institutions in Canada, we know that Aboriginal people are over-policed. We know that they're more likely to be held for bail. They're less likely to receive bail, and in turn, they're overrepresented in the penal institutions. Police in this city, and in other cities, as you've been reading, target Aboriginal people because they have this preconceived notion that Aboriginal people are criminals. The more policing that there is, the more arrests there's going to be. There are certain offenses that only our community members seem to get charged with. One of those is, Don was talking about his community being charged with the spanking offense. For our community, it's the drunk in a public place offense. We don't see police officers standing outside of the pubs at the University of Toronto targeting all the obnoxious drunk university students coming out of the pubs. What they're doing is they're targeting our community members to charge them with that offense. They take them down to the police station and they throw them in the drunk tank. We don't see many university students being placed in the drunk tank for the night. So target policing, that's racism. It's all about that person's race. And it's important that we call it what it is, and that when we're defending a person charged with those type of offenses, and now with the new Safe Streets Act, that we challenge the constitutionality of those offenses, and we call it what it is, we call it racism. And that we go ahead and lay police complaints. The problem that we have, and I'm sure many other lawyers have, and people have alluded to it, is that it's hard for us to find the right client to take these big cases forward. We were fired once by a family because they didn't want us to raise the Aboriginalness arguments that were in the case. They had 2 sons that died while in police custody. And it was so clear, videotaping, you know, the police just assumed that they were drunk. In fact, they had ingested poison. And they were ill in the cell. Well, one of them was in the cell. And the police just ignored them, thought, this is another drunken Indian, we'll just leave him lying there. Meanwhile, you know, normally when you're drunk, you sober up as the hours go on. This person was in jail for 12 hours, and he was getting worse. No medical attention was given to him. It wasn't until he was brought to bail court that duty counsel said, you know, what the heck is going on? This person needs some medical attention. And he died. And there was the police ran as fast as they could to try and have him released so that there wouldn't be an automatic inquest. And they wanted to make the argument that he wasn't in custody, so they wouldn't have the inquest. But in fact, he was in custody, so there was an automatic inquest. And we wanted to represent the family, or the family had approached us. And when we started saying we want to raise the issue of race and Aboriginalness, and how, you know, the police in Toronto are racist, and that they had the stereotyping of that your son was just a drunk Indian, that's why he didn't get medical attention. The family didn't want us to do that. They were ashamed. I mean, you have to keep in mind the history and the experience of that family. You know, people, we're told not to tell anyone that you're Indian or Aboriginal. So many clients were raised and told by their families that they were Spanish. You know, don't tell anyone you're Aboriginal. It's a no-no in Canada. You have to tell them you're Spanish. That's more acceptable. So, I mean, we had to, you know, it's hard to find the client that sort of wants to spearhead the argument and fight for the entire community when they're dealing with their own issues. So it's important that before you jump in, that you know, canvass the issues with your clients and you know, look at the outcome and make sure you have instructions from those clients. Let me speed up. Am I running out of time? Okay. So I've given you a couple of examples. I thought I'd give you a couple more examples of the work that we do where we raise Aboriginalness as an argument. And hopefully that'll assist you if you're in have a case that you might be thinking of attacking the racism. Some of the cases we do are, as Raj said, are direct attacks, or there's direct racism, and others are sort of the effects-based racism. I already spoke of the liquor license offense. That offense and the challenge to that would be under Section 15 and Section 7 of the Charter. It's vague, it's overbroad, it allows for way too much police discretion. What is intoxicated? That's not defined in the legislation. Police officers, if you talk to one or another, they all have a different opinion of what is intoxicated, whether it's falling down drunk or that you're belligerent. I mean, it's not an offense to be belligerent. You know, you can be belligerent, but the officers think if you're Aboriginal and belligerent, well, you're drunk and you're going into the cell. So I think that we need to go forward with the challenge. It has been challenged, but we have no higher court decision on it, and we've challenged it. And what happens is, every time we bring that issue up and challenge the actual legislation, the charge gets dropped on another ground, whether it be the illegal strip search that was done or the illegal detainment that occurred where the person's held for 12 hours. So they've been reluctant to sort of decide that issue. We also raise race and the Charter in civil matters. One case that actually we're working with Peter Rosenthal on is the circumstances surrounding a car accident. There was 3, but two young men are in a car. There's a car accident. One's white, one's Aboriginal. This is in a rural community. The police come, the ambulance come, they get taken to the hospital. The non-Aboriginal person gets immediate care from the police, the ambulance, and the hospital. And the Aboriginal person who is severely injured, life-threatening injuries, isn't given adequate care. So we've launched a lawsuit claiming negligence, but also claiming the Charter, that the reason why the Aboriginal person wasn't provided with the immediate care that he required was because the ambulance and the police and the doctors didn't view them as sort of worthy of treatment right away. So that'll be one of those cases where that Peter was talking about. You're not always sure you're going to win. It's going to be a hard case to show. Just, you know, the evidence of how do we show that the police are racist? Well, the evidence is out there that there's racism, but how do we show that that individual made that determination not to treat our client's son on the basis that he was Aboriginal and the other person injured was white. With regards to the administrative law area, we do lots of work in admin law. There's lots of arguments that could be made around one's Aboriginalness. One of the cases that we're working on is a challenge to the Marriage Act, which doesn't recognize Aboriginal marriages in law. So someone performing an Aboriginal traditional marriage, that ceremony is not recognized in law, so the people that are married don't have legal recognition as spouses. So that's one challenge that we're bringing to that legislation. Another challenge, going back to the effect of the legislation or the policy, is to discriminate against Aboriginal people. Is an example of that would be to the Criminal Injuries Compensation Board. They're refusing to hold teleconference hearings in institutions. They hold them everywhere else, but they won't hold one in a penal institution. So we're arguing with them that that's infringing our client, who's Aboriginal. And well, there's two arguments in that case, because there's also the issue of whether people in an institution are an analogous ground. But we're also, it has a negative impact, disproportionate impact on Aboriginal people, because we know more Aboriginal people are incarcerated than non-Aboriginal people. So I could, go on all day about the cases that we do, but I won't. So I just wanted to say that it's incumbent upon lawyers to review their client's case, their Aboriginal client's case, before determining whether to make the race argument. And that I just want to say that if you come across those type of cases, please feel free to call us. We love to speak to other lawyers that are thinking about bringing certain arguments, because it's important that, especially, we have lots of people trying to raise Section 35 arguments of the Constitution as an Aboriginal right, and sometimes those arguments shouldn't be made. There's some, for example, someone's trying to argue that it's an Aboriginal right to exclude their community members. And that was in the Corbier case. That's an Aboriginal right to exclude part of your community members from voting in the election. And, well, that has nothing to do with Aboriginal rights. The Indian Act isn't about Aboriginal rights. So sometimes we need to sit down with some lawyers that are trying to make those arguments and say, well, where are you getting this? And the Indian Act is not about Aboriginal rights. It took away rights. So please feel free to call us, and I guess I'll end there. Thank you.
Thank you, Kim. That was really interesting. I think there are a couple things that come out of that as well. One is the idea that sometimes, and Peter raised this as well, you just keep pushing race cases, and a reminder that if those of you are familiar with Brown versus Board of Education in the States, that seminal case, they tried a version of that case numerous times before they actually won on Brown. So let's keep those things in mind. And also the other theme that's coming out here is and everyone here I think knows this because you're here today, that race is an area in and of itself that requires expertise. Like if we think about areas of law like intellectual property and so on, that as practitioners we really have to take seriously the issue of race and racism and develop our own expertise. So on that note, someone who has a lot of expertise in this area is up next, Andrew Pinto. He practices in the area of civil and administrative litigation with an emphasis on employment, labor, and human rights law. He graduated from Queen's University with a degree in electrical engineering and obtained his law degree from the University of Windsor. Andrew was called to the Ontario Bar in 1995 and practiced for several years with Scott and Allen in Toronto before starting his own firm in 1998. Mr. Pinto acted as co-counsel in the Supreme Court case of Vreend in Alberta, and he's active in several community organizations. He's presently a member of the Law Society's Equity Advisory Group and the Executive Committee of the Administrative Law Section of the Canadian Bar Association. And I'm going to also just start passing out copies of Andrew's paper just to make sure that everybody gets one. They were outside.
Thank you, Michelle. I think I'm going to take the opportunity to actually stand for the opposite reason than Donald, because I'm a civil lawyer and we don't get to stand often enough. We're in our offices shuffling paper from one end of the desk to another. So what I've decided to do is actually not deal very much with my paper. think I echo some of the themes that our previous speakers have chosen. And what I find interesting is that working quite independently, we all seem to have chosen a fairly systematic approach. And I think the reason why I worked independently is it's a matter of time. When we're doing these cases, we often run out of time to speak to each other. And an occasion like this is an excellent opportunity to just make sure that we're on track. And I hope that today's presentation is some evidence of that. What I did in preparation for this presentation is to go back to some of my files, which are actually quite old by now, to look at the race cases and see if there was a theme that developed. And rather than talk about all of them or certain aspects from some of them, I've chosen to just go with one case that I think is very emblematic of the types of difficult issues that we deal with from the time that someone comes into our office. So I'm going to tell you the story about Pam, who is one of my clients, versus a large Canadian bank. Pam came to my office, made an appointment, came in, and she presented, if I can use that word, with really issues of simply being at home, being stressed out. She was depressed, she had headaches, back pain, and we sat down for a while trying to unravel what had brought her to this point. Well, it turns out that Pam had worked for a large Canadian bank for about 18 years, and about 15 years into her career, she started to feel that colleagues were bypassing her. Now, Pam is black, she's originally from Grenada, but certainly to my eyes and the way she presents, she is Canadian, she feels Canadian, and that's what she is. So from her analysis of her own situation, she was very reluctant to name race as the cause of her potential problems. But about 15 years into her career, she realized that a lot of other colleagues, other account managers had bypassed her. She was wondering why she wasn't particularly getting ahead. She sat down with a couple of the bank managers, and they identified the fact that she didn't have an undergraduate BCom degree, and this was really something that she could maybe do to improve her situation. So I think quite courageously for somebody in their late 30s who obviously had other responsibilities, she took a sabbatical, she took advantage of the bank's policies, and went back to school and qualified for a BCom with a specialist in finance. I think it took her about a year and a half to 2 years to do that, and she maintained a contact with the bank by doing some part-time work on the side. And she was repeatedly promised every few months that her job was still there, and they would be happy to have her back, and certainly they would look at enhanced opportunities for her since she now would have a university degree. Well, very soon, very close to the time that she had to come back, all of a sudden the message from the bank had changed. Now the managers were taking the position that there were lots of restructuring going on, and they couldn't guarantee her position. And what she now had to do was come into a branch. She was welcome to come into a branch and look up the bank's computer for any opportunities that might exist at her level. Now you can imagine this woman has worked hard to get a new degree. She's in her late 30s. She's got financial pressures, and what is she going to be doing looking at a computer all day for some opportunity that's in the Toronto area? So the bank, back and forth with some meetings with managers, even identified some positions. And when she did some research about these positions, she found out that they were things like almost equivalent to, say, a data entry clerk at the bank's data processing center, or that they would identify jobs that, when she asked the people about it, these were at branches that were slated to close within a few months. So she started to feel that there wasn't a lot of good faith in bringing her back to work. After a number of months, and you must remember I'm telling you the story in retrospect, but so this all happened before she came to see me. But after a few months, she actually managed to find a position at the account manager level at some branch, Yonge and Eglinton. And that's when her problems really began. She was made to feel extremely unwelcome by the head, by the branch manager. Things like social situations were very awkward. While she was in her office area or in her cubicle, she would notice that a lot of the other managers would gather in the mornings and have lots of jokes and laughter, and everyone seemed to be getting along, but when she would go out and say, hey, what's going on now? What's the talk? And everyone would sort of disperse. I mean, nobody was impolite, but there was clearly a sense that she didn't belong, socially or otherwise. She tried to raise this issue with the manager, who said it was, oh, I'm just a busy person. But she also noticed that another manager who was exactly at her same level and pretty much started at around the same time would have the ability to come in the morning and spend at least half an hour almost every day with this particular manager. So certain alarm bells started to go off with her. So what brought the situation to a head was Pam had to take her Christmas vacation, I believe. And about 2 hours before she left, the manager said that she now had to put into detail the job responsibilities for not only herself, but a number of other people in the bank. So she felt, quite understandably, I would say, that this doesn't really appear to be a priority when I'm leaving for my vacation in 2 hours and I've got other things to do. There was I guess, a verbal altercation in the workplace where where the manager swore at her. He didn't use a racial epithet, but he swore at her in front of other managers, causing great embarrassment to her. She considers herself and presumably the manager to be a professional. And, everyone looked the other way, and as is common in the workplace, nothing really was said about that. Anyway, an hour later, he approached her, pulled her aside and said, I really didn't mean to swear at you, but that's just how you make me feel. You pretty much, you drove me to it. So she goes on her vacation, comes back, and starts to get sick at work. She experiences depression, nausea, backaches, vomiting. She's in work one day, she's not in the next day. Any one of us who've done this kind of work have seen this symptom before. And so by the time Pam came to see me, it was really an issue of her not going into work. She was on short-term disability, and what I thought she was coming to see me about, what she thought she was coming to see me about is, well, I want to take advantage of potentially the long-term disability plan, or certainly continue on the short-term disability plan. But when I went to unravel her story, I asked her about the racial composition of the workplace. Well, she said that with the exception of a couple of bank tellers that were non-white, all the other managers were white. This particular manager, who gave her a lot of problems, was white, and she said that she felt it may be racial discrimination, but she didn't have a lot of evidence. Well, we started to dig a little further, and one of the incidents that she came up with, that she remembered, was that there was a dispute in the workplace about parking. Apparently the bank had to change the parking lot or something, and told the employees, well, make sure you phone this number and change your parking. So she did that, and then she was trying to arrange parking at another branch. So she phones the branch manager of another branch nearby, who is of South Asian origin, and in sort of discussing the parking situation, she said, yeah, I'm having a really difficult time at work, and I don't know what this manager has against me. And well, at that point, that South Asian manager confided in my client that she felt that her Pam's manager had a problem with minorities. And she also raised another incident, which, I'm presenting these tiny facts because they really are the way that you try and build a race case. She said that when this whole parking situation came up, Pam's manager had apparently been extremely rude to a parking lot attendant who is black, to the point that the parking lot attendant had complained to his manager, and there had been a dispute between the parking lot manager and Pam's manager. Well, now these are all facts that you're sitting in your office saying, what do I do with this? I mean, do I write a letter to the bank laying out this whole story? I mean, how do we build a case at all? So another factor that I looked at was the bank's own pronouncements about employment equity or the racial composition of their workplace. Well, this bank had glowingly reported that they had a task force from about 2 years ago, and that they had identified a gap in visible minority women, and the way Pam tells it to me, out of about 40 account managers at her level, when she went to meetings, she could not name more than 2 people who were non-white. To me, at that point, I felt that I had certainly enough evidence to raise the issue of race. I wasn't quite sure where it would get, but I wrote my, what we call, lawyers call demand letter to the bank, saying I want her to get a short-term disability, and if she needs a long-term disability, and if you can't do that, then it's constructive termination, blah, blah, blah. And I also decided to lay out some of the evidence of why I thought it was racial discrimination. I termed it that she's having difficulties with her employer, and this is the evidence that we had. Predictably, I got a letter from the vice president saying that, we take racial discrimination extremely seriously, and if there was ever a problem, we would rush to do something about it, and there is no evidence that this manager would discriminate against anyone. And what then happened was a negotiation between a vice president of human resources and myself. And what struck me the most in these meetings is that I expected the senior vice president of human resources to come in with, I suppose, a certain race discourse, as we would call it, or a certain attitude towards the problem, especially when I confronted him with his own report, which said that there was a gap in visible minority representation at a certain level. What I was met with was the whole discourse of, are you suggesting that we should promote your client because she's black? I mean, I was a bit struck by how unafraid this manager was to really confront me and my client that we were grasping for something that she was not entitled to. So what if she had gone to get a graduate degree? Everyone had graduate degrees. So what if a manager had some problems with parking? Either it was his agenda, or I'm not quite sure what, but he clearly downplayed the whole incident. So what took place in those meetings was my attempt to place Pam's situation in the context of a larger story, as we've all heard today, about systemic discrimination. And how could it both be true that you promote solely on the basis of merit, and it also be true that you have 2 out of 40 women, 2 out of 40 visible minority people? I mean, which one is it that you're saying? Are you saying that merit really results in an underrepresentation of visible minorities? I mean, if that's what you're saying, then that is racist. But it seems to me that respondents often want to have it both ways, and they're stuck with those cold hard facts. I think I've chosen this case to also illustrate some of the realities of what people want. I felt that I was pushing this argument. Pam, quite understandably, was somewhat in the background, a bit reluctant for me to raise this argument, but at the same time feeling that there was a lot of truth to what I was saying, but she didn't have the means or the ability to necessarily raise this argument herself. What happened ultimately with Pam's situation is that we ended up settling. She felt that she was so unwell that she never ever wanted to go back to the bank, and I essentially got her, I would say, a fairly decent termination package. But that experience, and once again, the reason why I chose this case, left me with a couple of lessons that I'd like to share with you. First one is that I don't know if I would have got the same results in terms of the termination package if I had not raised race. There was some evidence of disability, but it was really unclear. Headaches, nausea, I mean, that by human rights laws may not be a disability in and of itself. So the fact finding, which took several meetings with the client, was absolutely key to getting a story out. Secondly, on the medical evidence side, we had an extremely supportive psychologist who didn't necessarily raise race explicitly in her report, but mentioned enough about workplace stress that you could sort of read between the lines that without naming race, she was clearly implicating the conduct of the manager and some of the manager's differential treatment, and the psychologist went into some detail about that. So that was absolutely key, because all of a sudden it wasn't just the client's lawyer making a bit of a noise. It was a professional who has professional ethics and responsibilities to try and medically diagnose the situation, providing some objective corroborative evidence. So I would say that, as I've said in my paper, that the front end of a race case is absolutely vital. The first step I advocate is self-education, because if we ourselves are unable to really know race or to name it, we certainly aren't going to be able to do it on behalf of our clients. The next step is to translate that self-knowledge into an effective fact-finding for our clients, because it takes a while to unravel some of their stories, and the clients are just as involved in some of the myths about discrimination, and particularly about race, as we are and as the respondents are. I've indicated in my paper that a number of my clients essentially accept the racial hierarchy of the workplace. They accept that it's only natural that there will be a large number of minorities at the bottom, and the management, especially senior management, will be largely white, and this is just a reality that they have to live with. And when you step back, it's somewhat understandable. If you went into work every day feeling that that was a result of unfairness, it would be a difficult place to work. So I think all of us accept the world that is as it is to some extent, but I think our job here today is to change that. So I'm going to conclude my remarks there, in keeping with the time. Thanks.
Okay. At this time, I'd just like to thank this panel. I think that we heard a lot of excellent tips and insights onto racism in the law, but also about the really human factor and the toll it takes on people who experience racism. So if you can give everyone a round of applause, I appreciate that. Thank you. I'm going to move along to perspectives from the bench now and introduce Justice Omatsu. I'll give you a moment to